So thanks very much for the invitation. So thanks to Samuel and Jeremiah for organising. And thanks also to Mark and Jeremiah for a fabulous edited collection. I've got to say, when it was suggested that there was going to be yet another publication on VikingLaval, Jeremiah came to talk to me, said, "What do you think?" And my heart sank. I thought, no, goodness no. I can't read anything else on these bloody cases. And it's fantastic because it's such a wonderful book. And not just a wonderful book, but providing a set of new and fresh perspectives on the problems. So I think they're to be sort of warmly congratulated for the project and seeing what I couldn't see, because I lack imagination and they have copious amounts of it. And it's a very odd position for me to be stood talking to a room full largely of Swedish people on the right to strike, because of course I come from a country, and a strange country, where strikers, even in legal strike action, commit a repudiatory breach of contract and can be sued in damages, even if the strike is lawful. So I feel that kind of disqualifies me from standing here and pontificating to you here in the Valhalla of social democracy about the right to strike. So I'll say that there's an impediment here in my quality as an English labour lawyer to talk on topic. But I do have a particular advantage, which is I'm not an EU lawyer. And I think that is a particular advantage in thinking about the right to strike. Because I think when one approaches VikingLaval from within EU law, the analysis, I think, is pushed in a particular direction because one's engaging with the question within a particular normative structure, where you have a treaty that prioritises fundamental economic freedoms. So I teach a graduate seminar with Jeremiah, and one of the things that we discuss is VikingLaval. It's always a fantastic seminar. Everybody has something to say about it. People get very excited. But what we did this year was different. We decided not to begin with VikingLaval from within EU law. What we thought we would do is begin with VikingLaval from outside of EU law and start from first principles, thinking about the right to strike as a fundamental right in the international legal order. And it was a very interesting pedagogical experiment, because I think at the end of the seminar we arrived in a very different place because the starting point was different. We began in a different legal order, starting with different sets of normative assumptions about the right to strike and its role. And I think it's very interesting because to do that exposes assumptions and values that might be regarded as natural or otherwise remain invisible if you start within EU law. There are things that are taken for granted that you don't see. And that's true as an English labour lawyer. When you think about the right to strike from the perspective of English labour law, you're imbued with the common law, whether you like it or not. And that structures your thinking on certain topics. So we begin with the right to strike in the International Labour Organization. And the first thing to note is it's a right that is a constitutional right within the ILO legal order. Often mistakenly, people assume that the right to strike is derived from the right to collective bargaining in the ILO structure. And of course it isn't. The committees have derived it from ILO Convention 87 on freedom of association. And that now is regarded as a core convention because under the 1998 ILO Declaration, freedom of association is a core fundamental principle. But even before the 1998 Declaration, freedom of association has been constitutionalized in the International Labour Organization Constitution for a very long time. So you go back to the 1944 Declaration of Philadelphia, and there you see freedom of association and its incidents constitutionalized. And how could it be any other than that? Because the ILO is a tripartite organization. So you would expect to see freedom of association constitutionalized within a tripartite organisation such as the ILO. Now, if you look for a right to strike in ILO conventions, you'll struggle to find it. You sometimes get passing references to it in certain conventions, but there is no ILO right to strike convention, and there are various historical reasons why that's so. But that doesn't mean that the right to strike isn't fundamental to the ILO legal order. So the Tripartite Committee on Freedom of Association derived the right to strike from the general protection of freedom of association in ILO Convention 87. And that was followed subsequently by the Committee of Experts on the Application of Conventions and Recommendations, which isn't a tripartite committee, it's a committee of experts, but you see a high degree of convergence between both of those committees within the ILO structure on the matter of the right to strike. And it's a fundamental right with a secure status. And I think it's particularly important at the current juncture to emphasize that, because many of you will be aware of the activities, we might say antics, of the employer group within the ILO, which recently has rather aggressively pushed against the Committee of Experts, arguing two things. First, that the Committee of Experts as a body does not have authority to give interpretations of conventions that are legally binding. And actually, even if it did have such authority, it's not legitimate to derive the right to strike from ILO Convention 87. Now, the arguments are not new. The arguments have been ventilating for many decades. And really, I think there was a perception over the last decade that because the balance of power had shifted, the employer group could engage in more politically confrontational methods within the ILO. But I think what's very interesting about the arguments, aside from the fact that they're completely spurious, and I don't have time to go into why they're completely spurious, but it's very interesting to look at other forums internationally to see how the employer arguments have been regarded. So very recently, the European Court of Human Rights had occasion to consider the position in the ILO in a case called RMT versus United Kingdom. One of the UK government's arguments was that the right to strike should be regarded as based on an insecure foundation because of the opposition within the ILO. And the European Court very helpfully took the view that it regarded the employer's arguments as having no substance. And more recently still, in the Supreme Court of Canada, a remarkable case where a right to strike has now been recognised as arising under the Freedom of Association provision in the Canadian Charter. And the Supreme Court of Canada also had the opportunity to take a sceptical view on the significance of the employer group's position. So I think recent events within the ILO tell us nothing about the fundamentality of the right within that normative structure, and we should continue to regard it as fundamental. Now, we have to be careful about what that means to describe a right as fundamental. So in Jeremiah's presentation, he said, well, we shouldn't be all down on Viking and Laval because, of course, they've recognised the right as fundamental, and that's significant. But I think fundamental is something more than a merely textual description. If we're describing a right as fundamental, that has normative consequences to how the right is configured, and more importantly, how it's reconciled when it runs up against other rights and there's a need for a balancing exercise. So I think we should just, if the language of fundamentality is used, it's something more than a slogan. It has normative consequences for the constitution and operation of the right. So the right to strike, let's be clear about what that means. It's an ugly right. So the right to strike isn't like privacy or freedom of expression or the right to have a family. These are rights that make us feel warm inside. But the right to strike is an ugly right because it's the right to inflict intentional economic damage on employing entities. It's a fundamental right to inflict harm on an entity. That's what it is. It's an ugly right. Now, that doesn't mean to say that it's not a fundamental right. I think it is a fundamental right in the international legal order, but it's a right that isn't palatable to many constituencies. And actually, how seriously the right to strike is taken within a particular legal order tells you a great deal about that legal order's culture of respect for human rights. The right to strike is a wonderful barometer to test how seriously a rights culture is embedded within a legal order. Now, because of its nature as a right involving the intentional infliction of economic damage on employing entities, there's a particular sensitivity about the idea that we would balance the right to strike against the employer's economic interests. We've got to be very careful about that because of the nature of the right, right? So there are certainly jurisdictions where that kind of balancing occurs. So you sometimes find apologists for Viking and Laval pointing to the German system, where there is a system of proportionality, and the concept of proportionality is relative to the employer's economic interests. So by analogy, we're told that Viking is like German labour law, so we ought not to worry too much about it. And we've got to be very, very careful about that, because the devil is in the detail of what proportionality means within the total context of the German labour law system. And when German labour lawyers talk about proportionality, the extremity of the threshold needs to be emphasised. Industrial action is disproportionate where effectively there's intentional destruction of the employing enterprise. So the threshold isn't just interference with economic freedoms, the threshold is destruction of the enterprise. So it would be better to think of the German proportionality test as one of extreme disproportionality. And that gets us away from thinking that there's a comforting analogy to be drawn between proportionality EU style and proportionality German style. And I think the ILO has got it absolutely right. So the ILO, in the Balpa complaint, the Committee of Experts has said very clearly, ILO standards have never included the need to assess the proportionality of interests, bearing in mind a notion of freedom of establishment or freedom to provide services. Given the character of the fundamental right as the intentional infliction of economic damage, if we really take seriously the idea of fundamental as not just a textual slogan, but something of normative significance, this proposition has to be taken very seriously indeed. I will get this right at the end of the... There we go. So, should we be troubling ourselves with a reconciliation of ILO norms and EU law? So there are some legal and the answer to that, my quick answer is absolutely not. We shouldn't be seeking a reconciliation, and I'll tell you why we shouldn't be seeking a reconciliation. There are potential legal solutions that have been proposed to how we solve this apparent normative conflict between ILO norms and Viking and Laval. There's a fabulous chapter in the book by Steve Weatherall from an EU internal market lawyer's perspective, where he says, look, there's no problem with balancing. The problem in Viking and Laval is how the balancing exercise was undertaken, so that if the balancing exercise was undertaken in a more sensitive way, then that would be appropriate and we could sleep easily. And there's a very simple answer to that, which is the ILO committee is unequivocal that there is no scope for balancing, sensitive or otherwise. So if we take ILO norms seriously, Weatherall's argument, I think, is an argument that we should resist. But there are other very influential European labour lawyers, such as Catherine Barnard and Novitz and Serpis, who have proposed a similar kind of move. It's a move that should be resisted. It absolutely should be resisted. So another form of legal solution would be the Council of Europe as a conduit for the influence of ILO norms through Article 11 and the European Social Charter. This is what we would describe as the integrated approach to jurisprudence. So if the European Court of Justice doesn't take the ILO seriously, what might happen over time is that ILO influence will come through decisions of the European Court of Human Rights and decisions of the European Social Rights Committee under the European Social Charter. And these are things that juridically EU law might have to take much more seriously than ILO norms. So it's the idea I defend in the chapter of the Council of Europe as a transmission belt for ILO standards on the right to strike as a fundamental right. Now, as far as I'm concerned, there's only one solution to this, if you take the ILO seriously, one solution, which is an Albany exclusion in the context of the Viking and Laval litigation, because only then do you block a balancing exercise. And it's quite clear under the ILO that there is no legitimate scope for balancing. The only appropriate legal solution is through Albany. Now, there may be political solutions to think about alongside legal solutions. So one thing that we might need to think about is the possibility of dialogue between the ILO and the EU. So we have a form of rapprochement between these organisations. I think we need to be very careful about that form of political reconciliation, because the danger with that is that the ILO is in a position of weakness. We need to be aware of the power dynamics at the international level between international organisations, and the danger with that kind of political dialogue is that there will be a dilution within the ILO of ILO standards on the fundamental right to strike. And this is a problem I have more generally with defenders of what's called the integrated approach to adjudication at the international level, that we try and push different legal orders towards common standards. There is a danger with that because that can go in different directions. Maybe that will involve standards ratcheting up, and that's what I think people hope when they defend the integrated approach. But maybe it will lead to standards being ratcheted down. That's what we've got to be careful about. So we must be cautious about political dialogue between the ILO and the EU. I think the political solution that I find most attractive is the generation of political pressure on the EU using the norms of the ILO to point out here is an ugly legal conflict. The norms articulated by your court are not compliant with international human rights standards. That is a real legal conflict. The only way to solve that is politically. The institutions of the EU need to make a choice. And what I'd ask is, what is it to be? The prioritisation of market freedoms or respect for fundamental rights? Thank you.
Thank you very much. Now I invite Professor Birgitta Nystro from Lund University to comment on this. Want you?
Oh, do I stand up here?
If you can sit if you want to.
I'll stand. That's fine.
Yes.
So thank you for inviting me to this seminar, and it has been very interesting to listen to Alan now and to read the book. I'm very fond of the approach in the book, and it's also very interesting to read Alan's chapter where he examines the case law of the Court of Justice of the EU from the ILO perspective, and criticize the Court of Justice of the EU in the light of ILO practice, especially the use of this balancing, this proportionality technique. Alan also mentioned that he has a chapter where he sees the Council of Europe as a transmission belt between the ILO and the European Union. And the head of his chapter is the international law perspective. I would like to give a more regional perspective, the Council of Europe perspective, and maybe that could straighten out some questions regarding this transmission belt. I have some PowerPoints. Jeremiah's talked about the difference between the 28 countries of the European Union. Well, if we look upon, thank you. The Council of Europe, here we have the European Convention of Human Rights to consider. Of course, it has already been mentioned, and I don't think I will say very much about the convention. Here, the court in Strasbourg has extended the protection of the right to collective, the freedom of association under Article 11, to the right to strike, and further elaborated this right. But in its decision, the Strasbourg court refers to the social charter, and as they say several times, the social charter has a more specific and exacting norm. So I will discuss a little bit about the social charter. But then, referring back to Jeremiah's and the 28 different countries in the European Union, there are 43 countries that are parties to the social charter. So that makes it even more difficult. The European Social Charter's protection of the right to bargain collectively and the right to strike is found under Article 6, which I think already Alan mentioned. The Social Charter is supposed to be the first binding international treaty explicitly recognizing the right to strike. Also, the Social Charter contains a rule about proportionality, and that is a rather strict rule. Article G of the Social Charter says that the Charter shall be not be subject to any restrictions except such as are presented by law, are necessary in a democratic society for the protections of the freedoms and rights of others. And 3, they should be for the protection of public interest, national security, public health, or morals. There is extensive case law, a comprehensive body of case law from the European Committee of Social Rights, which is the supervisory body of the European Social Charter. The committee started already in 1969, so there is a lot of decisions taken by the committee. The case law, for example, says that the Charter encompasses both strike and lockouts, but also other forms like other forms of action like boycott, blockade, picketing. A starting point in the Charter is that strike action is protected only in conflicts of interests, not in conflicts of rights. the collective agreement is seen as a social peace treaty. During the duration of a collective agreement, strikes and other collective action are prohibited. There are some restrictions under this Article G, which I mentioned, and that refers to certain categories of workers, such as military personnel, judges, policemen. But such restrictions cannot, according to the committee's case law, be of a more general nature. Restrictions are also allowed if they take the form of procedural rules, for example, a notice period or a cooling off period. The legislative amendments in Sweden following the Laval case, the so-called Lex Laval rules, have not only been reviewed by the Committee of Experts on the application of conventions and recommendations in relation to the ILO Conventions 87 and 98, they have also been reviewed by the European Social Committee. And let me say some things about that. Så. Där. The European Social Charter is monitored by the European Committee of Social Rights. And there are two ways for the committee of doing this. First, it assesses the situation in states on the basis of the reports by the states. We know that from ILO 2, and that is the ordinary reporting system. But then there is also a possibility for NGOs or employers and employees organization to initiate a so-called collective complaint against a state party concerning a specific situation in the country concerned. And that was what LO and TCO did in 2012. They lodged a complaint against Sweden concerning the Lex Laval rules and argued that they were in contravention of the Social Charter. And the Committee of Social Rights found that there were a violation of the Charter on 4 points. 2 parts of Article 6 and also Article 19. And let's look into that in more depth. Article 6 concerns the right to bargaining collectively. And the Social Committee in the collective complaint first of all underlines that the right to bargaining collectively and the right to collective action represents an essential basis for the fulfillment of other fundamental rights given by the Social Charter. Article 6, paragraph 2 is the paragraph that especially deals with negotiations, voluntary negotiations, with a view to conclude collective agreement. And here the committee concludes that the restrictions and limitations by Lex Laval do not promote the development of a suitable machinery for collective bargaining. So that was the first ground of non-conformity. The second ground was Article 6, paragraph 4. And here we find the right to take collective action, including the right to strike. And here, the committee concludes that legislation that permits collective action only insofar as to obtain a given minimum standard, as Lex Laval does, infringe the fundamental right of workers and trade unions to engage in collective action for the protection of economic and social interests. So Lex Laval does not adequately recognize the fundamental right to collective action. Article 19 concerns the right of migrant workers, and according to the social charter, posted workers are considered to be migrant workers. And migrant workers staying lawfully within another country are entitled to treatment not less favorable than that of their own nationals. And in what that regards, among other things, remuneration and other employment and working conditions, and also includes membership of trade unions and the enjoyment of the benefits of collective bargaining. And here the committee says that Swedish legislation does not secure for posted workers lawfully staying within Sweden treatment not less favorable than that of comparable Swedish workers. I think it's also interesting here, we have discussed so much the balancing, and here we find that ILO is very clear here. There is no balancing. But the committee says, I've had quoted here, that the committee considers that legal rules relating to the exercise of economic freedoms should not be interpreted in such a way as in such a way as to not impose disproportionate restrictions upon the exercise of labor rights. So here is the balancing, but the balancing is clear. Labor right has more weight than economic rights. And we could continue. This was a quotation from paragraph 121 of the decision by the committee. In 122, the committee continues that the facilitation of free cross-border movement of services and the promotion of the freedom of an employer to undertake to provide services in the territory of other states cannot be treated from the point of view of the system of values, principles and fundamental rights embodied in the social charter as having a greater a priori value than core labor rights. And then it's perhaps also worth mentioning that recent developments regarding this, when it comes to the social charter, is that the ordinary reporting procedure for 2014 was Article 6 of the Charter, one of the articles that was examined. And consequently, since we still have the Lex Laval rules unchanged, Sweden was found to be not in conformity with Article 6, paragraph 2 and 4, with reference to the outcome in the collective complaint. And the committee's conclusions has not yet been considered by the Committee of Ministers, who can if they so want, adapt a resolution and may issue a recommendation, but that is rare. So, against the background of the supremacy of EU law, which we also have talked about earlier, Sweden now is in the interesting position to be in conformity with EU law and not in conformity with ILO standards and not in conformity with the social charter on 4 grounds. Well, I think that we will discuss this further, so I will not give any solutions or possible solutions, if there are any. I will just stop here by saying I think that there is a great need to find pragmatic solutions to settle this conflict between those international standards. Thank you.
Thank you, Birgitta. Now if the time schedule is very strict, then we have 3 minutes for comments and questions. Do you want the word, or should we? No. Okay. Is there anyone here who wants? We have 3 minutes. Nicola.
I just wanted to say something nice about the aesthetic value of the right to strike. I thought I should, which I said, defining it as an ugly right. There are some other, of course, viewpoints that we see it as just a right, at times an individual right, to withdraw one's labor, which is fairly straightforward, less ugly than the right to, destroy the livelihood of a decent employer or the livelihood of some non-culpable consumers. By saying that, I'm trying to say that it's the diversity of national traditions and national perspectives that should really also motivate being cautious about deferring to a particular forum, and that's why I find the Albany exception is particularly palatable. And although I agree with your idea that we should be cautious about deferring, putting our eggs in the human rights basket or in the, I think the ILO basket. I mean, this is another basket in which I wouldn't want to put all my eggs. Ultimately, I'm saying this may sound cheesy given that we are in a trade union room, but ultimately most of our eggs should be in this room. I mean, it's about the dynamics that will underpin, even in the governing body of the ILO, the discussion on the right to strike. I mean, just deferring to one approach, to one institution, is just not the answer. And I completely agree with what you're saying.
Okay, then there will be 10 minutes break, not more than 10 minutes, so we can rearrange the scene in here.
Thank you very much. That was great. Thank you. Yeah, that was great. Thanks very much.